Yeah. Wow, that's good. Keeps you out of trouble. I look pretty busy myself. There's a line.
And we're ready whenever you are, Mayor.
Good evening, and thank you for attending tonight's city council meeting. For those who are attending remotely, the camera in council chambers is set up to show those attending in person tonight. The platform we are using has a raise hand feature. You will notice a picture of a hand in the upper right-hand corner. When we reach the point in the meeting where the public has the opportunity to address council, you can click that button to be given your opportunity to address council. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Kathy, please call the roll.
Mayor Tulley,
Here.
Counselor Selly,
Here.
Counselor Powers,
Here.
Counselor Scamperly,
Here.
Counselor Stevenson,
Here.
Counselor Chivo,
Here.
Counselor Trim, quorum present.
Thank you. We have one presentation tonight from Acting Assessor Lachelle Dilcox regarding the 2025 real property tax.
Good evening, everyone, councilors, mayor. So we have this, So the 2025 real property tax cycle here is just kind of an overview of the assessor's duty and how they tie in with the taxes. And we begin up here in the top left in the winter where we're sending out exemption notifications for renewals and such. April 1st is our taxable status exemption filing date. That is every year. And that is, we have to have, if you have an exemption, nonprofit, whatever the case may be, that needs to be in by April 1st. Then May 12th, 2025, you see here is tentative assessment roll. It is actually the second Monday of May, so that will change each year. So it is today because our tentative assessment roll. Moving on here, we go to the May 16th, 23rd, and we have another date. We must have just gotten cut off here. No, I'm sorry. May 16th and the 23rd is our public notice for the tentative roll, and that goes into the paper, and Kathy got that taken care of today. So it will be in the paper for Friday and the next 2 Fridays, letting people know what days they can come in if they want to speak to me about their assessment. See if we can come to an agreement or whatever stipulated agreement concerning their assessment. On the 30th or earlier, we have the change of assessment notices from the county. The county produces those. We mail those. We actually received those today when I went and picked up the tentative roll. So those were put in the mail already. So those go out. Those indicate whether or not you have lost an exemption or if there's been a change in your assessment, whether it's been lowered or decreased. Then we go over here to May 22nd, May 30th, June 4th, June 7th with times for 2025. Those are the dates and times that are available by appointment for people who want to come in and speak with me regarding their assessment, a stipulated agreement, or, you know, if we can come to one where we can avoid going to the bar or not, you know, depends how it goes. The date of the bar or our grievance day this year, June 10th, 2025, is from 10 to noon, 2 to 4, and 6 to 8. And that is, you know, if there's no stipulated agreement or you don't want to come, you don't want to deal with that at all, the paperwork and all the things involved, you can come and bring your case to the bar regarding your assessment. We have the notice of bar decision, and that's usually, typically, I talked to Barb today, and she didn't give me an exact time or day or date because it really depends on how many people we have that attend the bar session. So, but she said typically, you know, it's just usually maybe up to a week, 10 days. I'm sorry.
Michelle, just for the people that are listening, BAR is the Board of Assessment.
Yes, I'm sorry.
Barlow's the chairperson, correct?
Yes, I'm sorry.
That's okay. Thank you.
I say it like everybody should know. Yes, the Board of Assessment Review. So August 1st or earlier is when our final assessment roll is out. And that falls into small claims if we're not able to, if they're not happy with the decision of the Board of Assessment Review, going into Article 7, right? And we put in here October 1st is the school tax roll. We're talking about school tax collection. We're going up here, and then we're talking February 1st is your city and your county tax roll going up into January 1st. And this big green arrow you see that was created here, this is when data collection is happening by the assessor or assessors, helpers, whatever. Reviewing permits, going through, seeing where people are at with their permits. If they've got a permit for building a garage, I want to see where they're at that building garage or house. Looking at updates on properties. If you have a permit for a demo, has it been demoed? Is it gone? Does it need to be removed? Those types of things, just to get us back ready to go into the following year. Like to also point out that we had talked about, Fonda and I talked about putting this into the city website under the assessment and just update it from year to year, because obviously the second Monday of May is not going to fall on May 12th every year. There are certain things that will change, and possibly I don't have anything to do with taxes, but this just kind of gives you an idea of how the assessment, my role as the acting assessor rolls into our taxes and how that's done. It's more of a visual thing. These things are on the website now, but it's kind of just blunt. It just kind of just says it. So this is just more for people like me that are visual. You can follow that little. I don't know. I think I've covered it all. If not, are there any other questions?
Thank you, Michelle. Any questions?
I have a question. People come to you, kind of like remnants from about 2 years ago,
Mhm.
we hired GAR to come in here and do that. Have you been getting a lot of people like that that never really settled their dispute with the city, things like that?
Well, I've gotten a lot of people that have come in, and I guess maybe I should specify as well that those dates and times that for the appointments are not set in stone. You don't have to wait until those dates and times to come see me or whatever. But yes, we've had a lot, mainly due to the fact that the increases, the things that happened in 2023, banks did not catch up to that until end of last year, beginning of this year. So people seen a huge increase in their escrow. And that's when people really notice, like when you don't see a difference in your escrow.
Right, I had
Yeah.
2 different banks, actually, the presidents called me and asked me the situation when it was happening. Nervous.
Yes, there a lot of people have seen a growth in their escrow, and so that's when they took notice. So I just started here in January. I've seen a lot of people that have come in to talk to me concerning their assessment from GAR.
Right. So anything that was settled around that time, I mean, if we expect to see a lot of change around that. I mean, if you made an agreement with GAR or the acting city assessor at the time, has there been a lot of changes to those agreements so far?
The agreements that were
That were
created in
agreed to.
2023
Yeah,
that were
23
agreed
and
to then.
24.
No, we do. I have had, a couple people that have come in and they have maybe not been entirely on board with what their agreement was in 2023.
Okay.
But after those discussions with those people, it felt more like we ended up
Worked
that
it
they
out.
were happy with
Okay.
where their assessment was in 2023. So whether there are some people that want to test having a new assessor in the office and see where that, or if you put it in context that, the Board of Assessment Review or whomever took you, you know, they took $24,000 off of your assessment, and this is where it puts you, and, you know, so when they can see those numbers again, the ones that came to an agreement, they seem to be okay with it. It just, they weren't, I don't think a lot of people were prepared for the change in their escrow. I think that that was a big shock.
Right.
Yeah.
And
Okay. Thank you.
Sorry, Dan.
Nope.
And a lot of that change in the escrow was because they were catching up, because they lost a year at the higher rate. So now they had to pay the extra for to have the shortfall covered.
Absolutely.
So it was a temporary large increase, and then once the shortfall was covered, it would go back to
Yeah,
a lower rate.
I'm really not, I've never had mine in escrow. Probably the only time in my life I was glad at that. So I was able to, you know, see it immediately. And so I don't know if I don't know how that works. I know a lot of people were negative in their escrow, and they were, you know, a little nervous about that.
Any other questions?
Mayor, may I make one comment?
Please.
I'll ask Lachelle to talk about the equalization rate, please.
Oh, okay, I'm sorry. Yes, so our equalization rate at this point is at 97%. I know Ogdensburg does have we have a pretty strong history of being at 100%. Currently, Bond and I are meeting next week with a plan going forward to get us back up to 100% and hopefully keep us at 100% without involving, we'd like to go back to what was working before. We stayed at 100% for many years because we had full-time assessors who were doing their due diligence and doing it by neighborhood. So where we fell apart and had to bring in GAR, I don't know, but because I wasn't involved at that time, but I feel like we have a pretty strong plan that we've discussed that going forward that will bring the city. And I know that we don't like hearing that we're at 97%, but I feel like we have a plan going forward to get us back to 100% and hopefully keep us there without that sticker shock that everyone experienced. So.
Lachelle, could you explain what happened? What creates that 97% versus the 100% for those that aren't aware?
Okay, so there are a lot of factors that go into it, but to keep it just really basic, when we have houses that are assessed at 80,000, but they're sold for 130,000 because of say no permit was got, and whatever. When we have things happen like that, where properties are being sold for a great deal, we have a lot more parcels or properties being sold at above their assessment rate. What happens is the state looks at all of those cells, arm's length cells, and if we have so many of them that it appears that we're not at market value. So that's the biggest one is if we're selling above assessment, so I don't know how to explain it any better than that. I have like this many papers that I've read, and it boils down to where we're at on the market, what we're selling our properties for versus what we have them assessed for.
And if I could just add, one of the challenges there is that whatever the equalization rate changes under 100%, it's blanket appropriated to every property, and that doesn't necessarily mean that every property should be, and that's why having 100% equalization rate is really ideal. I would say in this case, the 3% is relatively immaterial in the grand scheme. It shouldn't affect people's taxes in large part because of that 3%, but we don't like the trend. We want to make sure that we can turn that trend around.
And also I wanted to say too, when we were talking about that, the thing that was really kind of heartbreaking for people that got that sticker shock of this year with the change in their escrow was the fact that our taxes actually went down. So we've seen a decrease in taxes for those of us that were, so it was just kind of disheartening that we had taxes go down and there were so many people that weren't able to enjoy that. So, but
Okay, anyone? Michelle, thank you very much for this update.
Thank you.
At this time, I ask the consensus of council to amend the agenda to introduce a proclamation at this time.
Yes.
So no objection. Proclamation, the office of mayor, city of Ogdensburg. To recognize National Police Week 2025 and to honor the service and sacrifice of those law enforcement officers killed in the line of duty while protecting our communities and safeguarding our democracy. Whereas there are more than 800,000 law enforcement officers serving in communities across the United States, including the dedicated members of the City of Ogdensburg Police Department. Whereas since the first recorded death in 1786, there are currently more than 24,000 law enforcement officers in the United States that made the ultimate sacrifice and been killed in the line of duty. Whereas the names of these dedicated public servants are engraved on the walls of the National Law Enforcement Officers Memorial in Washington, D.C. Whereas new names of fallen heroes are added to the National Law Enforcement Officers Memorial this spring, including officers killed in 2024 and officers killed in previous years. Whereas the service and sacrifice of all officers killed in the line of duty will be honored during the National Law Enforcement Officers Memorial Fund's 37th Candlelight Vigil on the evening of May 13, 2025. Whereas the Candlelight Vigil is part of National Police Week, which will be observed this year, May 11th through the 17th. Whereas May 15th is designated as Peace Officers Memorial Day in honor of all fallen officers and their families, and U.S. flags should be flown at half-staff. Therefore, be it resolved that the City of Ogdensburg will observe May 11 through 17, 2025 as National Police Week in Ogdensburg, New York, and publicly salutes the service of law enforcement officers in our community and in communities across the nation. In witness whereof, I have hereunto set my hand and caused this seal to be affixed. We do not have any public hearings tonight, so that brings us to personal appearance. At this time, if anyone attending in person would like to address council, please come down to the podium and you will have 5 minutes.
Good evening, my name's Arlene Kai, a daycare provider. Like I said before, this is not about water and sewer while we're here tonight. It's how you're billing it. The new amendment charters 215 needs to be amended again for all home businesses, not just daycare. In January, only 35 letters went out to different codes, but you want to bring businesses here? The affidavits that were out in January, who's following up with the affidavits to enforce them? Because daycare providers sign the affidavit the same way as other businesses, and they aren't being charged. Why is daycare providers being targeted? But you would have regulate. You put regulate in the new amended chapter 215. That would be all home business. Can you explain what regulate means in chapter 215? So if you didn't sign the affidavit, you should have been charged. So they pay sewer rates, but they're not paying water rates in May. They pay their sewer rates, but now businesses aren't paying. Why? So since the last council meeting, 7 letters have gone out. And then letters went out in June, and the other letters in January. We're on these letters out after the city council meeting. So here we go, picking and choosing who will pay, not equitability at all. Looking forward to next meeting to see what comes up next, because this isn't going away. Need to see equitability with this code. I haven't seen it in the last 6 months at city council. Handing this letter to Kathy to put in the records.
Thank you, Arlene.
Good evening, council, mayor, city manager. since the issue of the water and sewer rates of home businesses was brought up again at your last city council meeting. And it's on tonight's agenda under old business. I thought I'd mention a few things for the council to consider for discussion. Again, as the billing procedure and enforceability seems to be an ongoing issue, it doesn't seem to be going away. What are residential home businesses actually being charged for? Are we being charged for assumed water usage? Or are we being charged for having a home business? Why is the city of Ironburg charging homeowners additional water and sewer rates for a residential home business when the issue is not about how much water is being used, since residential water is unlimited for a flat residential rate? The city has no data to support the city has no data to support a residential home business is using any more or any less water than any other home. The city does not have the means to tell how much water any one residence is using versus another. The city just can't assume that someone with a home business is using more water than anyone else. It's not right to charge additional fees based on assumption or what the city feels is being used. It needs to be based on facts and or reports. If you are charging based on the new definition of what constitutes a commercial residential mixed structure, there's no mention of water usage in that definition. So why does the city charge additional fees under water and sewer rates? Since you can't charge based on documented water and sewer rates, then you are basically charging people to have a home business. If that's the case, then everyone with a home business would have to be charged. I mentioned months ago that the new definition for the commercial residential structure that was developed was too vague. It seems to us and to others that the city appears to be picking and choosing who has to pay and who doesn't. From Reeser Foils, it appears that if you just fill out the affidavit and you don't have customers coming to your home on a regular basis, then you don't have to pay. Yet according to the Foils, some people are being forced to pay that said they don't, and others are not. And why were the people that did not submit their affidavit by the deadline and were charged appropriately able to come in after the fact and fill out an affidavit saying they didn't qualify and are not paying? There were 4 of them. Who determines if someone has customers regularly? And how is that determined? Because anyone can just say they don't have customers regularly. Regularly has many meanings such as daily, weekly, monthly, yearly, frequently, and often, which would mean most home businesses qualify. On the other hand, each of you got a handout with a suggestion on it. It's only a suggestion for council and city staff to consider as a possible alternative. Suggestion: develop a new home occupancy business permit with an annual flat rate fee of $165, or whatever the city may feel is a reasonable fee. At the time the permit is issued, initial inspection will be scheduled for a future date. Inspection every 3 years at $90. It includes all home businesses, which is any organized effort to produce and or sell goods and or services to customers for a profit, aiming to meet societal needs while generating revenue. Then you'd have to amend or remove the current code and the definition under the water and sewer section of the code. This is a cut and dry process with no gray areas. This is no different than other permits people must get to do things within the city. Vendor permits, peddler permits, building permits, etc. If you have a home business, you get a permit. The enforcement will be the same procedure as the enforcement as the other permits, either by the city or by law enforcement. It is a way for residents with a small home business to contribute and support the city financially and for the city to collect revenue. This could be the most equitable way to proceed. I'll let Smith this.
Thank you, Mr. Snyder. Now, if anyone attending remotely would like to address council, please use the raised hand feature. The city clerk will recognize and unmute one person at a time, and you will have 5 minutes.
The first individual is registered as Greg McNamara, and I will unmute that individual now. It appears you are self-muted. It appears your line is open.
Hello, can you hear me?
Yes, sir.
Thanks. Tonight I'd like to discuss something. I wanted to discuss some other things, but the way the city just radiates negativity, there's not a lot of good news at any of these meetings. Hopefully this can turn into something positive. The former Diamond National property at the end of Madison Avenue, there's a gate that's the last 8 years, working on 9 years I've lived here, was open almost the entire time. A couple of winters it was closed and locked. And I was told it was because they didn't want to do the snow removal there, which, whatever, that is what it is. This past fall it was locked, and I was led to believe by management and a council member that it was for the winter time again. May 1st, that gate should have been open. There's a whole list I can think of opportunities down there before we do move forward with that property. It's a beautiful area. It's a great place for fishing. There's hundreds of feet of deep water shoreline there. And I've seen anglers catch some amazing northern pike, and I have myself down there. There's good, awesome skyline views, photography opportunities. I've seen kids come down here, and I don't want to say all the activities they do because we'd be worried about that. Let's say throwing a football back and forth. They're just having a good time, you know. The list goes on. Currently, down in the shipyard area, this has been going on for a couple of months. There's a major problem with a group of thieves. I could name, I'm not going to out of respect for the businesses, but I could name 5 known businesses that they've hit really hard when they were closed. I believe leaving this gate closed is facilitating their mischief and escape opportunities throughout all of these instances. And they keep coming back. They're relentless. Me and these business owners are all on a first name basis and have each other's phone numbers so we can follow these people one night, because when you call the county, you're lucky if the cops call you back 20 minutes later. When you're following an active burglar, you can't, that doesn't work, that system, unfortunately. Since this administration, we stopped maintaining the Maple City Trail as well in the wintertime. We stopped maintaining an access to the Maple City Trail, which was always part of the Maple City Trail. Some people that I've talked to were told it's not. It is absolutely, it's been on Google Earth for years. It is an access, it is part of the Maple City Trail. And it's a steep hill, and I was given every excuse in the book. It's dangerous. It's just crap. That's what the DPW job is to maintain this stuff. It's what it says in the municipal code. It's what it says on their website. And nowhere does it say they can pick and choose. You know what I mean? It's just their job to kind of make sure these things are maintained. Now, I was told that it was due more or less to liability issues, but I would make the argument, and this is at the Diamond property and the Maple City Trail, but I would make the argument that it increases greatly liability issues because it's still accessible. Both properties, one way or the other, if someone would need to be rescued in the St. Lawrence River in front of the Diamond property, let's say a boating accident happened or something was to happen, law enforcement or rescue crews can't even get down there. They come to a locked gate when they could drive right down and be at the river's edge. Since this administration, we've also added employees to the police department and to the DPW, but for some reason we're now reducing some of the services that have always been provided, which is troubling to me. I would appreciate it if all of you discuss this stuff this evening, so the voters and the residents that are listening to this meeting know where each and every one of you stand on my thoughts here. I think it is, having that gate locked is creating liabilities. Not plowing the Maple City Trail is creating liabilities. In 2019, I believe a man was rescued who walked out on the ice underneath the arterial bridge on the Oswegatchie River. I believe he escaped from the psychiatric center. Don't quote me on that. But he was in the water swimming for 20 minutes If they couldn't drive the emergency vehicles on the Maple City Trail to rescue that man, he would have drowned. It was amazing he swam as long as he did. People go ice fishing, people cross on their snowmobiles. They were this year under that bridge. And unfortunately, we don't have a designated bridge around here for snowmobilers to cross. And I would never try that, but they do it. And someone might need to be rescued there. I'm just looking through my notes here.
But please try to.
That's about the gist of what I have to say. And I think leaving this gate locked, once again, is nothing but facilitating the criminals that the police cannot catch because of the system we have. And it's actually making a more dangerous situation, and it's lessening the recreation for the good people who live here in the city. Thank you.
Thank you, Greg.
I do not see any other hands raised, ma'am.
So that brings us to correspondence, and we have one letter tonight.
Yes. Dear City Councilors, first and foremost, thank you to the Ogdensburg first responders, our firefighters and police officers who responded to the recent fire on Riverside Avenue, as well as the firefighters from Canton, Hubleton, and Lisbon Fire Departments. As a community, we owe these brave individuals a debt of gratitude. This very unfortunate event could have been avoided, though. 2 buildings located at 502 Riverside Avenue have been abandoned for decades, and it was well known that individuals were breaking into and squatting in the buildings. Neighbors have filed complaints with the city in the past, but no action has been taken. The parcel 48.071-2-1.2 is 6.46 acres and owned by MCYC LLC out of Morristown, New York. Many years ago, the property was home to the Augsbury Oil Company, who were good neighbors. As you know, that company closed in the 1980s, and the property has sat idle for decades with little prospects of redevelopment. As you know, the westerly structure, brick building on the corner of Riverside Avenue and Franklin Street, has been completely destroyed by a fire that has been labeled suspicious. 1 woman was injured in the blaze. We are writing to the City Council asking for action to clean up this longstanding eyesore and hazard. Specifically, we are asking the city to do the following. Westerly structure. For safety and aesthetic reasons, we are requesting that the building be completely raised and that the area be topsoil and seeded in order to prevent erosion and runoff. We are also requesting that the city not allow the debris to be buried or otherwise disposed of on site, but rather trucked away to an appropriate landfill. In addition to the debris, including large amounts of soot and charred wood, the parcel is a former petroleum site. In addition, we are requesting that curbing be installed like the rest of the area along Riverside Avenue and Franklin Street in order to provide for a more orderly intersection of Riverside Avenue and Franklin Street. Currently, it's hard to delineate where the public right-of-way starts and ends. It should be noted, almost a week after the fire, the structure has only been secured by a flimsy yellow caution tape. There does not appear to be any effort to secure the area with appropriate fencing, temporary chain link, or post the property with adequate signage. Easterly structure. We believe that this structure should be condemned and demolished pursuant to section 97-10C3 of the City of Ogdensburg Code, Unsafe Buildings and Structures. Subsection 3 states, quote, in any case where an unsafe building is so damaged or decayed or deteriorated from its original value or structure so that it cannot be economically restored, it shall be demolished. In all cases where a building cannot be repaired so that it will no longer exist in violation of the terms of this chapter, it shall be demolished. In all cases where an unsafe building is a fire hazard existing or erected in violation of the terms of this chapter or any other provisions of this code or laws of the state of New York, it shall be demolished, end quote. This building has been out of use for almost 40 years. It is also clear that the property has not been regularly maintained. Neighbors have witnessed individuals entering the property on a regular basis. We believe that this structure is covered by section 97-10C3. Rezoning. The parcel is currently zoned mixed use. The areas surrounding 502 Riverside Avenue are zoned residential. We are asking the city to begin the process of rezoning the parcel as part of the adjacent single-family resident district. The neighbors are eager to see this parcel redeveloped in harmony with the existing neighborhood uses. Our neighborhood is an appealing area to live in close proximity to the St. Lawrence River, Morset Park, city-owned marina, city library, Remington Museum, and downtown Ogdensburg. Ongoing maintenance. We are also hoping to get more support and enforcement from the city relative to grass and brush on the property. Many areas of the property are overgrown with brush. Section 83-1 states, quote, "It shall be unlawful for any owner, lessee, or occupant, or any agent or employee of any such owner, lessee, or occupant having control of any occupied or unoccupied developed lot or developed land or undeveloped land defined as waterfront area by chapter 135 of this code, or any part thereof in the city of Ogdensburg to permit or maintain on any such lot or land or on or along the sidewalk, street, or alley adjacent to the same, between the property line and the edge of the roadway, any growth of weeds, grass, or other rank vegetation to a greater height than 10 inches on the average, or any accumulation of dead weeds, grass, or brush. It shall also be unlawful for any such person to cause, suffer, or allow poison ivy, ragweed, or other poisonous plants or plants detrimental to health to grow on any such lot or land in such manner that any part of such poison ivy, ragweed, or other poisonous or harmful weed shall extend upon, overhang, or border any public place, or allow the seed, pollen, or other poisonous materials or emanation therefrom to be carried through the air into any public place," end quote. In closing, we are seeking action from the city after decades of inaction and before something even worse happens. Our neighborhood is a great place to live. Many of us have raised our kids in the neighborhood or are currently raising kids in the neighborhood. The state of affairs at 502 Riverside Avenue is not the future of Ogdensburg. We need to do better if we want our community to flourish and grow. Nicholas Wallace, Jack McIntosh, Barbara and John O'Keefe, Andy and Eric West, Tyler and Jamie Caro, Debbie McDonald, Donald McDonald, Molly and Garth Ryan, Brittany and Thomas Kelso, Michelle and Vincent Catlin, Brian and Hillary Mitchell, and Cindy Cole.
Right, next we have our consent agenda that the claims as enumerated in general fund warrant 9-2025 in the amount of $786,793.37. And library warrant 9-2025 in the amount of $0. And capital fund warrant 9-2025 in the amount of $619,270.58. And community development fund warrant 9-2025 in the amount of $0. And community renewal fund warrant number 9-2025 in the amount of $0 as audited, be and the same hereby are ordered paid. I so move.
Second.
Kathy, please call me.
Mayor Tully,
Yes.
Counselor Selly,
Yes.
Counselor Powers,
Yes.
Counselor Scamperly,
Yes.
Counselor Stevenson,
Yes.
Counselor Tebow,
Yes.
Counselor Trim,
Yes.
approved.
We do not have any appointments tonight, so that brings us to items for council action. Our only item of business will be read by city manager Fonda Cronis.
Thank you, Mr. Mayor. A resolution authorizing the city manager to sign legal services agreement with Stagg Liuzza LLC and Wallatus Law Firm PC for the purpose of providing legal services related to the filing of a civil action and/or claims in the pending settlements for recovery of costs associated with damages to the public drinking water system and/or public wastewater system against defendants who manufactured, marketed, distributed, and/or sold aqueous film forming foam in the aqueous film forming foams AFFF litigation.
Move that.
Second that.
So we'll give a description of this item.
Certainly, this is very similar to previous opioid legislation, class action lawsuits. Apparently, as I am learning more about this, the AFFF materials are in the foams that put out fires. And what has happened over the decades is a lot of that has gotten into the drinking water system and has caused trouble in wastewater systems as well. So there are a number of lawsuits against the companies that produce these chemicals. And it makes sense for the city to sign on, so it makes sure that it does get its due deserved dollars from the settlements.
And as I read the agreement, there are no attorney's fees to the city unless we do have a recovery. In such case, the attorneys get a portion of that recovery.
That is correct. It's a contingency agreement.
Questions or comments? Kathy, please call the roll.
Counselor Powers,
Yes.
Counselor Scamperly?
Yes.
Counselor Stevenson?
Yes.
Counselor Tebow?
Yes.
Counselor Trim? Mayor Tulley?
Yes.
Counselor Silly?
Yes.
Approved.
This brings us to old business, and we'll begin with Fire Chief Ken Stull with the discussion on home business timeline.
Good evening. I was asked at the last council meeting to give an update of how we're looking for more at-home businesses. Thought it might be worthy to go over the timeline of events that got us to today with the new counselor and for the citizens. So sometime in 2020, an Ogdensburg resident and home business owner addressed concerns with the city council that her double rate water and sewer bill was unfair and not equally applied. This resident continued to address these concerns all the way through 2024 and occasionally in 2025. Through in November and October of 2024, through a listening council, we established a process to try to identify a list of parcels that may meet the commercial residential mixed structure classification and the associated billing issues that were addressed to the council. November 12th, 2024, at a council meeting, municipal code language and billing schedule changes were made through a council resolution. The wording of what the change in language for a commercial residential mixed structure was that a structure containing one or more commercial or office units in combination with one or more family units. This definition applies where the commercial or office space is regularly used for business purposes by patients, clients, or customers, or where goods are assembled, produced, manufactured for resale. Each commercial or office unit is treated as a separate unit for billing purposes. The user fees to be calculated at 50% of the residential flat rate and 50% of the minimum metered billing rate for the appropriate meter size as determined by the city engineer, director of public works, or city manager. These amounts equated to an annual sewer rate increase of $95, a water rate increase of $70. This is on a 3/4 inch water line, where the old calculation would have been $567 and $418 respectively. So starting in November of 2024, probable at-home businesses were identified initially by an anonymous list that was provided to the city. This list included daycare providers, registered daycare providers. The daycare providers requested an exemption as they needed to be considered a family residence by New York State in order to qualify to be a registered daycare. Management sought out a legal opinion on the daycare request. January 7th of 2025, letters and affidavits were sent certified in regular mail out to the original properties of the anonymous letter. Property owners were given the opportunity to confirm or deny their classification under the new adopted language through a signed affidavit. Property owners were given until January 31st, 2025 to voluntarily comply to this request. As a result of these letters, 7 confirmed, 20 denied, and 6 did not respond. Through this process, 10 properties were assessed the increased rates. Daycare providers were withheld pending a legal opinion. March of 2025, it was determined by New York State and legal that as long as the city applies the policy to all home businesses, does not solely focus on daycare providers, that the city can assess the rates to daycares. April 16th of 2025, letters were sent out to registered daycares of the decision to apply the additional water sewer costs to these properties. The letter stated if they disagreed, the property owners could have their properties removed from the New York State registry, and this would exempt them from the increase. So to get to what you wanted to know, what we're doing now. Weekly, the St. Lawrence County docket is reviewed to identify any LLCs or DBAs that are established within the city. Once it's determined that they were established, we try to see if they meet the requirements for the additional billing through discretion and or additional letters of affidavits. We've been using the website opengovnewyork.com to identify businesses within the city. Additionally, businesses are identified through social media and the internet, along with identification properties by city staff through other various means. To date, an additional 8 properties have been identified as possible home occupied businesses. In addition to that, we have found 4 standalone businesses that actually open up in commercial buildings without getting permits. So we were able to get them inspected and hopefully on the sales tax roll. So that's where we are with that. Just some information and some considerations for citizens and council. Code enforcement is not police enforcement. There is no judge or jury. Codes are always civil in nature. They're not criminal. Code enforcement is based on voluntary compliance. With most issues, it is very limited as to what can be done, especially in a private residential dwelling. Home businesses issues have been both manpower and financially taxing on the city. This is a result of years of not addressing the issue. Through continued monitoring, citizen compliance, The workload will decrease and more properties will be identified. As with any new city policy, especially when money is involved, not all citizens are going to be happy. Management is in the process of establishing a business registry. For the last 2 weeks, we've been using our software provider to establish a business registry that will be on the city's website with information for anyone that wants to open a business, either standalone or at home. I just recently, this afternoon, got the email on the cost associated with that, and I plan on discussing that with the city manager tomorrow. This registry will provide much needed information to potential businesses, as well as streamline the identification and compliance issues of the past. In closing, it is vital for the city to continue to identify these properties. It is important to know if and what type of business is inside a residential structure as a matter of safety. It's also an issue of fairness for all citizens. Additionally, identification and education of these businesses can and will provide much needed revenue sales tax for the city. So at this point, I can answer any questions you may or may not have.
Questions or comments from council? Go ahead.
I just want to say thank you for that. Really comprehensive, detailed.
Just a question. So people who have residents in their home, all right, they're providing a room, shared kitchen, bathroom, things like that, from a state, they're getting paid by the state or some other agency like that. Do they also, kind of similar to the daycare, have to get approved and inspected? Are we using that list?
I don't know of any list of those. If there is one, we could absolutely use that. I know the daycares kind of felt like we were kind of soloing them out, but we really weren't. Unfortunately for them, they were the only ones that have a website that you can confirm they have a business. I could send each of you a letter asking if you have a business at your house, and tell me no, and without a way to follow up and prove that you have it, I can't go in your house. So that concern has been brought to me by several citizens. I don't know what that website would be, but
The concern that I just presented,
yes,
because they brought it up here too.
correct.
I think it's a legitimate question. I think somewhere they've got to be registered as a home. I mean,
Yeah, and when I spoke to one individual on the phone, I explained that I do remember one of these home care facilities because it was my friend's grandmother that did it. She's no longer alive. So I don't know of any other ones in the city other than that one, and that no longer exists. So not saying that they don't. I just personally don't know where they are. I don't know where any business is in anybody's house. So it's hard for me to find them other than the means that we're using. And again, it's voluntary compliance. If you don't come to the city and say, hey, I'm selling flowers out of my house or something along that nature, I have no way of knowing.
You're referring to like a home dwelling SRO kind of thing, like you're renting out a room with privileges?
I think what he's referring to is there's some individuals that have, they might have 4 or 5 residents, like they call them clients that live in their house. And there probably is some sort of governing agency, but nothing that's been brought to my attention.
So the question I would have, and I've had this concern since we changed the statute regularly. I just don't know, that's so subjective. You know, if you send me a letter saying you regularly have clients, customers that come to your home, I might think that means open from 9 to 5 with people coming and going all day long at their pleasure. If I might not consider it regularly if somebody stops by twice a week and does business with me. I'm still very concerned with that regularly. And I would like us to consider and get some feedback on this separation from water and sewer for businesses and make it more equitable and more enforceable or clear to people with a permit instead of tying it to water and sewer. Because we've heard from citizens as they sit here that they don't feel they're using any more water and sewer than the neighbor next door with their business, so they should be charged this. But that doesn't mean they're not having a business in their home. So I think that we should look at the permitting process versus tying it to water and sewer. I think it would at least give us some clarity on this. And there's a lot of people unhappy about how this is being enforced and about the inequity in that. So I would like us to consider, Fonda, if we could, to at least look into the permitting process. Maybe there's some examples from other cities, municipalities that have this versus tied to water and sewer.
We'll put it on the list. I'm
I know
not
the
sure,
list
I'm
is
not
big,
so
but
sure.
This is kind of important.
I think The reason we went this route is because of the concerns of the one citizen who was obviously paying more than she absolutely should have. And that was addressed through water and sewer. So we tried to fix it through water and sewer, the means that have always been there. I'm not saying that something new, better idea isn't out there, but we didn't just decide to pick water and sewer. We just addressed it through water and sewer. Actually, the resolution, I think actually came more. So I don't know how else to explain it. So.
And Chief, I understand that completely. I just think that I think there is a better way to do it. And I didn't think about a permitting process until this was brought forward.
It's pretty evident that this is still obviously a work in progress, and as Fonda mentioned, addressed, and I'm sure we'll have many more lengthy discussions related to it.
So Chief, I think it's important that we get a written copy of what you shared with us tonight, so we have something to look at. Read it again, read it a third time, read through the information, additional suggestions that made to council tonight, so that we can continue the dialogue discussing this issue. I don't think any particular group was singled out. And again, as you referenced, daycare does have a source that the city could access, but absent the resources to go knocking door to door, again, it becomes a voluntary compliance issue, as the chief mentioned. We're trying to make every effort to be fair to our citizens in dealing with home business use of user fees for water and sewer. So I know we're trying your patience. I do think management, quite honestly, last fall came to us with a reasonable definition, which council unanimously supported. Okay, and after listening to input from citizens, we reduced the amount of that additional fee from $1,000 a year to $150 a year. So I think we made reasonable strides there to try to be accommodative to the home businesses in the city. I don't think there are any ill intentions, and I guess I'll leave my comments at that for now.
I can provide you with the letter, and I have a bunch of other paperwork. I didn't have it ready in time for the meeting because I was preparing the next update, and I was also trying to be a fire chief for a little bit last week. So, thank you.
Thank you.
Thank you, Chief. That brings us to new businesses. Everyone have any new businesses? I should return to old business. Any other old business that they brought to the floor?
I have some old business. So that's all right. The Diamond property, and I know we've had some email exchanges. For anybody that hasn't been paying attention, I'm trying to get an RFP going. Fonda, first of all, I just want to say thank you for your responses. I appreciate that. I appreciate the fact that as a city manager, you want to have your ducks in a row. And that's what you're demonstrating to me. And I don't blame you. I appreciate that you recognize my frustration as well. But I just, when we're looking at this, we've got to have a way to develop this property. And surely the state can give us millions and millions of dollars to clean it up and then not be able to develop it again. This group that met with you in January with the concept, I mean, they're looking at a $30-40 million project here, and they just want a phone call. And I think if you call them within the next day or two, I think we can get you and the attorneys and everybody sort of in a line of moving forward some way or another. And that's all they're asking for. And that's what I'm asking for. Is I hate to see it go away. And I know they're getting impatient. They call me every day and trying to move forward. But they're talking to the wrong guy. They need a call from you, and I've told them this since January. And I think if we get, it seems like they're versed at this stuff. Leasing property that's, under this inalienable clause. I'm sure that they've got their attorneys on it. They've sank a lot of money into their concept plans, they're ready to roll, they have financing. And I just want to move forward before we step back and lose it. Really appreciate it. Give me a call.
Yeah, Councilor Scamperly, as I said in my email response to you, I said I would give them a call at my earliest convenience, and it didn't quite make the schedule for today, so I'm going to shoot for tomorrow. I'm happy to call them, but I can't in good conscience move forward on something when we have an opinion from the city attorney that says you probably can't. That doesn't mean that an opinion makes it fact, and we'll do our due diligence, but it's hard for me to move forward on something when I have an opinion from an attorney that says you probably should hold off. And that was the whole point of the conversation.
So when I was looking at his opinion, don't really see a whole lot in here, and I might have missed it, about the lease. I know that we can't transfer the property without these steps, but it seems like even the court case that he cited, the city of Glen Cove was leasing their property, and then they wanted to sell it. They couldn't sell it. So I have to go with Andrea Smith on this one, and that this property can be leased. But like I know you suggested in your email, let's get a third opinion. And I think if you talk to these guys, they may be able to put that in the right direction, with the city and everybody else. But they really want a phone call.
Sure, just to add some context to it, although it doesn't say it in the opinion itself, I did ask the city attorney in regards to lease, and he said that the lease would be treated just as a sale. So that information, whether it's a lease or it's a sale, he considers it the same thing from this court case. And certainly this property has been developable since 2014. So, we're talking significant period of time here. Nobody wants that on the tax rolls more than the guy who has to balance your budget every year. So it pains me to have to maybe put the brakes on this a little bit, but I think it's really important that we have our ducks in a row before we go ahead and move forward. We get a sign off from a third party, or we have conversations and the opinion changes for whatever reasons. I'm certainly ready to move forward on it. Shane and I walked the property last week, as a matter of fact, and we talked about infrastructure and all the things that have to happen. And so we're certainly thinking about it and looking to move forward on it.
Good.
With that being said, Fonda, I believe a couple of council meetings while I was remote, I had asked if there were any hindrances. If I recall correctly, when Diamond National when we first started this endeavor many years ago, I think it was when I was on council in 2008 to 2012, there were restrictions. And I know that it can be legislated out, which will be a task, of course, with itself. But ultimately, at the end of the day, recognizing the legalities that are in place, probably still wouldn't hurt to maybe have a presentation, ladies and gentlemen, after the fact, after you've got not to add more things to your list of daily obligations here, but ultimately to quickly get a resolution or an opinion so that we can somewhat kind of, like you said, you're the one that has to balance the budget. The quicker we get something developed or moving in that manner would be advantageous, obviously, to the city, to its coffers. But if we have to legislate it, we might have to maybe take an angle at that at some point, which would be time consuming. Wouldn't cost us any money. It would just create a lot of lobbying with our state representatives, but ultimately, I think they'd be able to get that done, maybe under some aspect of home rule legislation. So, it might be just a sign off of budget season, state budget. At the end of the day, March 31st, when the last weekend, that's usually when home rule gets done, right? So, just a thought, just to throw it out there, to continue in this endeavor.
So a presentation would help the cause, you're saying?
Well, after we get all our ducks in a row, once we find out what our legal aspects are, and then, if there are any, or if Fonda gets another opinion and we have another loophole, or not a loophole, but an avenue to pursue, and then if not, then possibly legislate it, and then get the ball rolling to show that there's some enticement to it, and have them commit into a presentation.
Right.
Just have your ducks in a row, so that when we do have to push it to legislate it, we've got ammunition.
Right.
My thought is that we need to seek a formal opinion from the Attorney General's office. They make decisions on municipal contracts and decisions and sales and stuff all the time. I know several cities have been prohibited from selling parkland and golf courses unless they had enough space to replace it. You know, this land doesn't fall into that category, but I think a formal decision from the Attorney General's office would put all the other legal considerations to bed one way or the other.
So these guys are trying to basically form a partnership. Like I said, I imagine they have experience, with the city, where the city retains ownership and nothing can happen without approval. And at least that's the way they're explaining it to me. I would suspect that this happens quite often around the state. I mean, I can't imagine they give us all this money to clean up this property and say, but can't do anything. I mean, the sales tax that I'm looking at, just in the sense of vibrancy from what their proposal is to boost this whole city, every restaurant and bar and hotel is just they're gonna want it. I mean, why wouldn't you? And I just can't imagine that wasn't the purpose, was to clean up this property so that it can be developed.
I'm frustrated. This decision from the attorney predates Fonda by several years. And I recall when the place was cleaned up, there were restrictions put on it as to what could and couldn't be built there. And they talked about things that private residents could do and apartments and condominiums could and couldn't do. But I don't ever recall it coming out into the public purvey that we were prohibited from selling any waterfront property. I don't know what administration or who was in charge or whatever, but I just don't, Dan and Mike have been here right along, but I just don't ever recall that coming out as public knowledge.
I do. I remember it. I remember it was city manager, it was Art Chiara at the time. And I know that this dais had quite a lengthy debate back and forth as to, having that property developed and having the ability as a governmental entity in the city to be able to advance it with the possible restrictions that were put in by the state. Now, you're dealing with a different executive and legislative branch, at the time, many different people in both the Assembly, Senate, and the governor's office. But I don't know how that's laxed or if it's laxed at all, or, I don't even know if they abide by it anymore. God only knows the state of New York. But, really, with that being said, it's, I can sense your frustration and I agree, but I always felt that there was something that was hindering that. And because it's been a clean lot for a long time, and, to be able to develop it has always run into hurdles and, some far-fetched ideas that have come our way over the past and fruition. So it's a hurdle. It's going to be a hurdle. I'm afraid.
I look forward to the third opinion because I didn't serve under Art Shura, but during the time I was in council previously, I don't ever remember that coming up as we were getting it ready for development. We're spending city taxpayer dollars on it. So I'm very concerned that we thought we could develop this all along and it hadn't been brought up more than once to us previously. So I look forward to it.
And again, I think the important next step is getting the legal opinion. But if you find an avenue for a way to develop this property, I think a presentation is premature without going through an RFP or RFQ process to give any developer an opportunity to submit a bid or an idea to council. So I think a presentation by the company you're talking to at this point would be premature without following an RFP process of some nature.
And I concur with that. And if I didn't explain it that way, that's on me. But ultimately, at the end of the day, let's get our ducks in a row legally and find out what can be done with that property and what capacity, or look to remove any of the restrictions that the state may need, and then proceed with potential options for development of that property.
On an expedited basis.
Yes, sir. And with that, obviously, I don't want to put the cart before the horse. And You know, I'd never do it that way if I didn't explain that adequately. That's on me. But I concur. You know, and have everything in a row before we have anybody come forward.
And I agree, we need to go through the process. We can't market something that we don't know what can be done with it.
Right.
So I would really need to get that settled.
Last week, they've got a lot of investors. They've got, so they say, you know, they've got concept plans. The timeline now is they're looking at apparently a forward New York waterfront grant that they think they can secure $80 million to go ahead with this project. So they're trying to, they want to go ahead. So they want the RFP process to go through. They want to give a presentation to the city during that process to, as Fabi says, what does the city want? Give the city a chance to weigh in. Do we want this? I mean, I agree with it. And, well, I'm not the sole decision maker, neither is anybody, right? We're here to do what we think is best. But now they're looking at that grant. And something like that, they tell me, is about a 2-year out process, right? Just to get the grant money and secure it and move. But there's deadlines for applying and things like that. So they're waiting. And the biggest issue, like I said, is they like a phone call. And if they get that, I think a lot of this could be fast forward. Because I think they're versed in what they're doing. So I think if Fonda calls them, and maybe with Mr. Goldie or another firm, they can get pointed in the right direction. We can get some viable opinions on maybe what we can. I think Andrea had it down pretty good. So there was a question in the city asked Andrea. She knew the answer. She usually like that. And so I trust her on that. And I told these guys back when they were trying to get me to bring this forward, as he got talks to them, he's being in charge. And I also told them I don't think you can purchase the property. I think it has to be like a partnership with the city of some sort, which is why I presented these. I'm just assuming that the person, I don't know. I'm not going to. A phone call will bring it all the way. Probably take a couple. I don't know. But I just think a plan in order. They want some hope, or I think their investors are getting tired of waiting. Their perspective, 6 months ago. Just wanted to get that out there. And again, Fonda, I appreciate it. And I honestly think your experience in Watkins Glen, I know you want to get this done too. I think you're the man to bring this on. Something, whether it's this or something else. Like I said, I appreciate you having all your ducks in a row, and I trust you. So, thank you.
Any other old business? Now that brings us to new business. Any new businesses?
I have 2 items, Your Honor.
Yes, Jim.
Both could be construed as new business, old business, but I brought them up under new business. The first, is there a reason why the Diamond property is close to fishing enthusiasts? Because that's always been a great area for people to be able to go out and fish. And from what I understand, I don't fish myself, but I understand that that's one of the better places to catch some of the bigger carp and things like that. So I'd like to see what it would take, and if there's a reason why, I think the public should understand why we have the gates locked. But if there's not, then I think we should open it up during the season.
Well,
It's been
I
in the
reported
past.
to council that we locked it up because of liability issues. Shane and I walked it. We've talked about a couple of different solutions, but there is, a couple of concerns that go along with Mr. Goldie's opinion that I want to make sure we don't set ourselves up for failure on this. So for the short term, we're going to keep it closed pending some information that comes by. If we can open it up and it makes sense to do so, we can do so safely. Shane and I have discussed a couple of options. I think right now we have to stay the course while I get a couple of questions answered.
Sorry, I did not see that email. My apologies. I'll look for it.
No, we talked about it in council. I believe I reported that there were some vandals that had cut the fence
Yes.
and had entered, and so we made the decision to close it. I can't recall if it was via update or whether it was a discussion here.
I remember the cutting the fence. I just didn't realize that it was going to be long-term shut. So my apologies. I'll look at that. But I would like to revisit it if we can, get further information. And secondly, is the building on Riverside. Yep.
We fenced off all of the waterfront that public connects to the city park. Is that-
I don't know if we have a policy on that, but Diamond certainly is fenced as well as Shade Roller. And then although we don't control it, I think most, if not all, of the Oxbury properties are fenced to a certain extent, although as I drove by the other day, a couple of the fence openings were wide opens, you know, but again, privately held, city doesn't control those properties.
No, not at all.
Can I comment on that too before you move on to the next issue? Just because Greg asked for us to each share or express what we think, and I've said it before, I think the gate should be open. I fought hard years ago to get it open for fishermen. I realize a few bad apples can ruin it, and the city is facing other liability issues. And I also know there was some horseplay down there, which Wanda discussed with us, which was part of the reason to close it. I think Greg makes some good points. I think that you make some good points. People want to access it. I'm looking forward to a reason to open it. You guys can come up with a method to opening it, shall we say. So I support opening it as soon as we can.
Let me just caution council that that is not a park. That is not a city park area. And once you open land that's owned by the city to the public, it becomes public access property, and that makes it even more difficult to do some of the development things you want to do. And so those are some of the questions I'm trying to get answered, right? And although I didn't necessarily want to talk about that because people are like, well, that doesn't make any sense. Well, those are provisions within New York state law that we have to follow.
We'd run into all sorts of trouble with our insurance. With that being said, you know, if it's not an open park or an open recreational area, such as, I don't know if the city owns Father Martin anymore. No, that was gifted over to the club, wasn't it? But at any rate, you know, any of those open vacant properties, you know, our recreation fields or anything of that nature, but something that doesn't have adequate safety or access, you know, if you don't have adequate access to it or open access to it, our first, if somebody gets injured in there, our first responders may have difficulty getting it. So it's a sticky wicket, so to speak.
Everything's gray here in the city of Ogdensburg.
While
It's
we're on
open
the
to
topic of
interpretation.
these particular types of properties, can we get an update on the property on the Riverside at Elizabeth Street and Riverside Ave? The gate's wide open, but they're all dirt in and out of there. Somebody told me there was some cleanup or something going on there, but I don't even know if the city owns that land or what it is, but again, it doesn't do any good to fence all that stuff off when there's a truck size gate hole there, people get in, and we do have a homeless population that was living on that property over by the boat ramp, so that area. Last summer, I don't know whether they're planning to move back in now, the snow's melted.
Can you tell me
Maybe
the
they're
I think that was volleyball court or the volley was in. You talking straight down Carroll?
No, Elizabeth Street,
Oh, the pile.
the other side of the old,
Pile.
the other side of the other
Yeah.
Augsburg method.
They had that covered it. Covered the wall.
It had barrels in there. The other night I was down, drove by, and I noticed it looked like somebody been dumping dirt or something in there, so I have no idea what's going on. I just thought maybe we could get an update on that.
And just to follow up on that, it's one of the things I was going to ask, and I know Jen's going to go into it herself here, about the properties with the recent fire and the old office space further down the eastern side of the city. Who owns those? Obviously, the city took ownership of that fire during the fire, but who is the private owner? Is there a private owner of that? Has the city acquired that?
LLC that was formed by Malin Clemens. I don't know whether his estate is that or the LLC still in existence or what. But they were the owners of that.
I don't know if there's any avenue, and I'm surely not looking to spend any more money for lawyers or anything, but, you know, that's, we've got the Seaway Festival coming up, and a lot of people walk down along that way. And I really hope that we can get that cleaned up, you know, and even have that other building raised in some capacity, working with the owners or, you know,
That was one of
filing, you know, going after them over code violations that were very clearly outlined in the letter, which we're all familiar with, you know, but, you know, in some capacity.
That was one of my frustrations in my last term on council, is how long it takes us to get fire damaged structures taken down. And I was, you know, informed it had to do with the insurance companies coming in and things like that. But I notice other cities, when they have a fire and they condemn something, it's leveled and cleaned up, and built to whoever the owner is in pretty short order. You know, you do see some abandoned buildings standing forever, but I can think of 3 or 4 places here in the city that have had fires. It's been 4 or 5 years. They're still just boarded up, along with a lot of our condemned structures that are, you know, they're boarded up, but nothing ever seems to happen with them. They don't get rehabilitated. They don't get torn down. Some of them are being turned over to the land bank and they've been doing something with them. But it seems like a process that just takes forever.
So
I don't know if there way to speed it up.
Recognizing that process, you know, if we could stay on top of that in some capacity to help try to get that blighted properties.
Yeah, and code enforcement has actually come to me with some ideas, and we're going to get together and talk about some of those things to try and expedite what you're talking about. But to get back to the ownership question that you have, there are 3 properties there in Augsbury. The middle property is owned by Kiwanis, and I do believe that the county is going to end up taking control of that. The left and the right side properties are owned by different conglomerations that all kind of do point towards Malin Clemens, who has passed away. I have been in contact with the son, who claims that the estate doesn't have any money. I don't know if I want to use the word bankrupt, but doesn't have any money. He certainly knows about the fire. We're certainly going to encourage him to move forward. But remember, the city does not have foreclosure powers anymore. So there's a different governmental entity that we need to start working with. I'm happy to say that we do have a meeting with them in a couple of weeks to start talking about these issues so that we can be working together as opposed to kind of going in our own separate directions. So there's no easy answer for any of this stuff. No question about it. Like I say, there's very little black and white. It's all in the grays and how things are interpreted and how we can move forward. But the conversations are starting to happen, and that's what gets progress started, is the conversations.
So the second item I had for old business was the Riverside Avenue property. And I myself drove by there this afternoon on the way to city council. And that is just a playground waiting for an accident right now. You know, it's interesting to kids to go playing there. It's very precarious the way some of the walls are still leaning. There is caution tape that is not even attached to anything now, it's blowing in the wind. We had some fencing that was obtained by our former state assemblywoman, Patty Jenny, that was given to us to use if we had tour ships come to Ogdensburg to gate off the area. There's some extensive fencing that was gifted to us for that purpose, and we've used it for other purposes during the issues we had with flood damage along the Greenbelt. And I think that we should consider bringing that kind of fencing or something along that line to at least give it something more of a permanent blockade to let people know not to go in there, not to check it out. And you know, we as adults, I think, would not go in there, but that isn't to say that we wouldn't have kids climbing in there. It's very dangerous. So I'd like to see if we could do something better than what we're doing right now.
We'll look into it and do the best we can with what we have.
Thank you.
Any other new business? That brings us to items for discussion. We'll begin with Fire Chief Ken Stowe with vacant property.
I think I can answer some of the issues and questions that were just brought up. Just going to start by saying that I'm probably going to sound like a broken record. I'm going to keep saying voluntary compliance. Also, Mayor, I will provide you this letter, so you don't have to ask for it after I'm done speaking. So in light of the recent Channel 7 News update story on blighted properties, I decided to address the issue tonight rather than wait till the 27th. The issue, the city's problem with blight, condemned, and abandoned structures is not exclusive to Ogdensburg. These issues are not only evident in neighboring communities, it is also a state and national issue. The recent fire in a vacant factory in Gloversville, New York, and a vacant commercial building fire in Oakland, California last week, which happened to be the 6th time that particular place caught fire in 2 years, is evidence of a widespread problem. Now I'm going to address the fire on Riverside Ave. It is important to note first, this property has been vacant for as long as I can remember, and I've lived here my whole life. It is true that we've had incidents there involving fires, squatting, and trespassing. In the one past fire incident, squatters were using fire as a means to provide warmth for themselves. Following the incident, the property owner was notified and did not seek to pursue charges of the individuals for trespassing. Myself and Police Chief Kearns were both on scene. At that time, we provided assistance to the homeless individuals through the Adult Protective Services, assistance that they did not take advantage of. Also, money was provided from our own pockets to assist them so we could get them out of the structure. They actually wanted us to let them back in so that they could take out their returnable cans. So we did a quick assessment of what we thought the cans were worth. We gave them our money so that we could move them along. These individuals were later found in other vacant properties. Following the incident, the property owner was ordered by code enforcement to secure the building to keep people out. The owner actually complied, and up until recently, the building had remained secure. I can guarantee this, all winter long, every time we had a snowfall, I personally drove down to see if there was any footprints, to see if anyone was going in. Same thing I did with the cheese plant before we tore that down. There wasn't any activity all winter long. In light of the recent attention, as a result of the fire, it is important for representatives and citizens to understand what can and can't be done by city departments. Firstly, most of the issues involving vacant abandoned buildings are addressed by code enforcement and are civil in nature. They are not criminal and require voluntary compliance. While trespassing is absolutely criminal, if a property owner does not seek charges, an arrest cannot be made. So now I'll give a hypothetical abandoned property in the process at which codes addresses it. The building is recognized as being vacant or abandoned by codes. An assessment of the property is conducted from the street unless the property owner gives us permission to go on the property or in the structure. Following the assessment is determined what needs to be done to secure this property for the safety of our citizens. Remediations that are considered are disconnection of services, which include gas, water, and electrical, boarding of the structure to prevent people from entering and to reduce continued deterioration of the structure, fencing if deemed necessary, and signage to identify the condition of the building. Occasionally, demolition of the property is ordered. The property owner is ordered to make these remediations. Most often than not, they absolutely do not comply. At this point, the city conducts these remediations either with city staff or we hire contractors to do this. This comes at a cost to the city. Any costs associated with this are then levied on the property's taxes, most of which are already delinquent. The cost also includes civil penalties per the municipal code. Through the tax foreclosure process, the city is eventually made whole. This could take anywhere from 12 to 18 months financially, and in some cases, the properties do get purchased, rehabbed, and put back on the tax rolls. This is not a very common occurrence. In most cases, these properties are not purchased at all, or they are purchased sight unseen from people from outside the area. These buyers often do nothing with the properties when they realize how much it would take to bring them up to code and just let them go back up for tax foreclosure. This creates a revolving issue. Code enforcement is very limited in what they can do other than issue notices, apply the civil fees, or have the violations corrected through the use of city funds. The most common issue with these buildings is neglect of the property owner. Most of these properties are delinquent in taxes and service charges already. As a result, all orders by code enforcement are ignored and compliance is never met. The only avenue we have to get the properties properly secured is through the use of city funds which are very limited. The frustrations of the citizens are well known, as are the effects these properties have on our neighborhoods. What is not known is the frustration of the code officials. Code officials apply the code to these structures, order remediation that never gets completed, and have no real means to make it happen, as they are civil in nature. Cases in which the owners have or intend to walk away from the properties and avoid all responsibility. The problem is only magnified by an increasing number of homeless, mental health and substance abuse issues within the city, and an unstable economy and the rising cost of goods and services. So what have we been doing? The Codes Department has a well-developed list of these properties and a system in place to identify them. This list dates back to 2017, when the city had a grant-funded zombie inspector. While this position no longer exists, the inspector has become one of our code officials. As a result, this list has not only continued to be a part of Code Enforcement Department, it is routinely updated. The updating includes adding and removing properties as their condition changes, finding grant funding opportunities for larger properties, such as the cheese plant, and monthly visual inspections of each property to address any condition changes and to maintain proper securing of the boarding of the building, which would include boarding. Recently, through a monthly inspection process, 1 week after the fire on Riverside Ave, it was identified that boarding was removed from a structure, one of these structures. Upon further investigation, we found that a fire had been intentionally set in the upstairs bedroom of the structure. Fortunately, the fire burned itself out before engulfing the whole building and the neighboring house, which was only 5 feet away. The OPD is currently investigating this incident. This particular incident is a representation of the overall problem. The building was identified and the property was secured at the city's expense. And someone removed the boarding and entered the structure. The neighbors stated that they noticed the board was removed a couple days prior to us noticing it. This information was never relayed to any city department. The codes department is actively addressing the vacant property issue, which takes a great deal of time. Grants are continually sought out and education is provided to keep us up to date with the aspects of these types of properties and what we can and cannot do in relation to them. Also, we have begun the process of establishing a vacant property task force. While this is still in its infancy, we intend to comprise it of code, fire, police, management personnel, along with members of the community and hopefully elected officials. So I am looking for volunteers. The goal of this task force will be to continue what we are currently doing with the properties and expand upon it by looking into other ideas and options. The city has recently reached out, as the city manager stated, to St. Lawrence County on this issue. The county has a well-established blight and remediation program. It is our hope to partner with the county to work toward reducing the number of these properties within our city. We will be meeting with the county relatively soon, and updates to the progress will be forthcoming. In closing, it is important to note that these properties are not being ignored by the city. We are also very well aware of the effects that they have on our neighborhoods. These properties are more often than not a result of irresponsible and absentee property owners. This is not neglect on enforcement, but more of a lack of means, both legally and financially, for the city to fully remedy the problem.
Well done.
Thank you, Chief.
Questions or comments?
I'd like to address the fencing issue of the city manager doesn't
Sure.
mind. I actually spoke with the director of the DPW this morning on the fencing. We do have the fencing. It was actually also utilized for the cheese plant. We can use it, he said, but he would like the council to be made aware that it also gets used for the Seaway Festival, which is coming up. We did give the property owner notice to tear down the fire burn structure and to secure the other one. The time has recently expired, so now the city has to move on to the next step of deciding whether or not we're going to spend city funds to do it or seek other avenues.
Can I ask a question? Is there no legal recourse against this property owner who's not complying?
So the only, no, we can get court orders. We've had, in the past, we've got court orders to go into people's property and clean them out, and they can't stop us. But again, it's all at the expense of the city, and the property owner will just go on their tax levy, and they don't plan on paying the taxes anyway, so, or they don't have the funds even if we were to sue them.
But again, I think as Fonda brought up, we have a different, we have a card in hand here, right, the county. So partnership.
Yes, we're looking for a partnership.
Okay.
Fonda, you started to mention it, Chief Stoll mentioned it, but since we changed our tax collection from the city to the county, it seems to me that we're very limited as to what we can do when somebody doesn't pay their taxes. It's all dependent upon the county foreclosing and then working back with us instead of us doing it ourselves.
Well, what we do.
Is that an advantage or disadvantage?
Well, I think it's 6 of one, half dozen of the other. In many circumstances, when the county is foreclosing, the city isn't upfronting the cash to all the other municipalities. That's a win for the city. But in these circumstances, the city's only recourse is to do the work. For example, take the time to clear out this whatever debris is left, right? There's a cost to that. That cost gets put onto the tax bill. And when foreclosure happens in 3 years, the county makes us whole. The problem is when you want to work with another municipality, You don't want it to be, well, we're just going to do this and then you pay the bill in 3 years. Eventually that's going to get old. We want to have a process in place, an agreement in place, maybe not a formal agreement, but just, these are the things that are going to happen. And maybe the small ones, maybe they really don't have an opinion of, but maybe the big ones they do. I don't know. But until we start having these conversations, I am very hesitant to just move forward and just put all of these collections on the tax bill and just say, well, the county's just going to make us whole in 3 years. I think that's the wrong approach.
Rightly so, the relationship with the county is a bit pretty strained. We really need to work to improve.
And they have programs that we don't have access to, and we may have some access to different programs that they may not have access to. And if we put our heads together, maybe we can come up with something. This is a much bigger problem than we had a fire on Riverside Avenue. This is a blight problem. It's been here for decades. This is a homeless problem. And then all of the reasons why homelessness occurs. And it's an economic development problem as well. So these are not things that we're going to solve overnight. I think Chief's got codes in a really good direction. He's really taken, the bull by the horns on that, and they're doing everything that they can. But it is frustrating. It's certainly frustrating for them. It's frustrating for me and management. I'm sure it's very frustrating to council, and you represent the citizens at large. But again, I continue to say this, and I will probably say this for my entire term. These are very difficult, what we call in the business, wicked problems. There's so much into it. You can't just say, okay, we're going to do X, Y, and Z, and poof, the problems are over with. You can hear, the chief getting into the details. There's lots to this. And yeah, can we put up fencing? That's a very easy thing to do. It won't be so easy when we need the fencing in 2 places at one time. And can we get in there and probably clear out the debris? Yeah, but that doesn't really fix the big problems that we have. And that's why I think it's important to start having these conversations now.
I agree. It is important to have these conversations. And Chief, I appreciate you explaining to everyone what codes are against, trying to enforce this. It's not an easy problem that you just go in and clean it out and say to people you're trespassing. The owner has to have responsibility with this. I would like to see issue some type of fencing there sooner than later. If we're concerned about Seaway Festival, that's 8 to 10 weeks away. I'm concerned about tomorrow and today. We'll see. So I hope that we can consider that.
Okay, we'll be discussing that tomorrow. I will share one other story with you just to understand what codes is up against. Within a few weeks ago, we had a complaint from a citizen that there was a camper next to her property that's undesirables, what she called them, we're living in it. Through myself and code enforcement officer Dolmage, we met with the property owner who didn't own the trailer, the camper that was on the property. We spent 2 weeks dealing with the person, threatening to take it, but we really couldn't because we didn't have any means to remove it. They finally agreed to sell it and get rid of it. So it went away along with it with 2 unregistered vehicles that were on the property. So we considered that a big win for the city, only to find out that it moved from across town to Grant Street. So this is the problems that we're facing. So we're at first base right now with that same camper that we've already moved once. So people are resilient when they want to be. Thank you.
Thank you, Chief.
Thanks, Chief.
Thanks, Chief.
Other items for discussion? Hearing none, that brings us to citizen participation. At this time, if anyone attending in person would like to address council, please come down to the podium. You will have 2 minutes.
Barbara O'Keefe, 100 Franklin Street. I have a question. One of my frustrations was we watch people go in and out of these buildings and they're not secure. All the attempts to block off windows and stuff, they have been down forever and haven't been put up. The building on the east side today, one of the garages, all the whole bottom is kicked in. There's 2 windows that aren't boarded up. Is there anything you can do to board up these properties? Or the same thing's gonna happen to the other building? And we were just lucky, there was no fatality. So, There's nothing we can do?
I'll research the question again with management with code enforcement and try to come up with an answer.
Okay, thank you.
Off the cuff, I don't have it.
Yeah, Barb,
The other building's completely open.
we'll look into it, Barb.
Thank you.
We'll give it more attention.
Now, if anyone attending remotely would like to address council, please use the raise hand feature. The city clerk will recognize and group one person at a time, and do that 2 minutes.
I do not see any hands raised, Mayor.
We have a resolution to adjourn to executive session that I will introduce. Whereas City Manager Fonda Cronus requested an executive session with members of the Augsburg City Council to discuss matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. And whereas New York State Open Meetings Law permits City Council to adjourn to executive session for such purpose. Now therefore be it resolved that City Council adjourn to executive session to discuss matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. And be it further resolved that any action resulting from this executive session shall be taken in open session. I so move.
Second.
Kathy, please call the roll.
Counselor Scamperly?
Yes.
Counselor Stevenson?
Yes.
Counselor Tebow?
Yes.
Counselor Trim?
Yes.
Mayor Tully?
Yes.
Counselor Selly?
Yes.
Counselor Powers?
Yes.
Approved.
I'd like to note there'll be 3 matters discussed in executive session. 2 of the matters will be inviting Chief Kearns to join council. The other we will be inviting Chief Stoll to join council. We do not anticipate any action coming out of executive session, so I'll make a motion to adjourn the meeting from executive session.
Second.
Second.
All in favor? Aye. Meeting is adjourned after executive session.